ಆಗಿ ನಾವು ಏನು ಮಾತಾಡಕ್ ಹೋಗಲ್ಲ ಸರ್.
I think you answered. And the silly thing, embarrassment is the pension fund. I make myself. No, I will ask the president. This should be content. I will ask my bar president. No, this should be content.
Number 9, speaking. Young Sharat Chandra, correspondence.
Yes. SCGP.
The offense below the law set into motion by as per your PW1 Shashi lodged a complaint before the police as per exhibit P1 we found in your page number 99 of your paper.
Yes sir.
ನಮ್ಮಲ್ಲಿ ಮೂಲಕ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ದೊಡ್ಡ ಆರೋಗ್ಯ ಸರ್ವೆ ನಂಬರ್ 7 ಜಮೀನು ನನ್ನ ಮಾವನ ಸಂಜಯ್ ಗೌಡರ ಹೆಸರಲ್ಲಿ ಈ ವಿಚಾರದಲ್ಲಿ ನನ್ನ ಮಾವನವರು ಅವರ ಅಣ್ಣ ಬಳ್ಳಾರಿಗೌಡ ಮತ್ತು ಅವರ ಮಕ್ಕಳಿಗೆ ವಿವಾದವಿದ್ದು ಈ ಹಿಂದೆ ಗಲಾಟೆ ಆಗಿರುತ್ತೆ. ಈ ದಿವಸ 27/2012 ಬೆಳಿಗ್ಗೆ 7 ಗಂಟೆ ಸಮಯಕ್ಕೆ ನಾನು ನನ್ನ ಗಂಡ ಗಿರೀಶ ನನ್ನ ಮಾವ ಸಂಜಯ್ ಗೌಡ ನಾವು 3 ಜನರು ನಮ್ಮ ಬಾಪು ಸಭೆಯನ್ನು 73 ಇನ್ನೊಂದು ಜಮೀನಿನಲ್ಲಿ ಹೋಗಿ ವ್ಯವಸಾಯದ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಾವನವರ ಅನ್ನೇಗೌಡ ದೇವೇಗೌಡ ಅಲೆಕ್ಸ್ ಬಳ್ಳಾರಿಗೌಡರ ಮಗ ಕೆಂಪೇಗೌಡ ಉಳ್ಳೇಗೌಡ ಅಂಡ್ ಜಯರಾಮ ಬಳ್ಳಾರಿಗೌಡ ಹೆಂಡತಿ ದೇವಮ್ಮ ಇವರ ಹೆಣ್ಣು ಮಕ್ಕಳಾದ ಲಕ್ಷ್ಮಿ ಮತ್ತು ಹೀಗೆ ಮಕ್ಕಳಾದ ಆಶಾ ಮತ್ತು ಉಷಾ ನಂಬರ್ 6 ಲಕ್ಷ್ಮಣ ಗಂಡ ನಿಂಗೇಗೌಡ ನಂಬರ್ 7 ಇಷ್ಟು ಜನರು ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ನಮ್ಮ ಜಮೀನಿನ ಕಡೆಗೆ ಬರುತ್ತಿರುವುದನ್ನು ನಾನು ನೋಡಿ ನನ್ನ ಗಂಡ ಇದ್ದ ಕಡೆಗೆ ಹೋದರು. ಮೇಲೆ ಕಂಡವರು ನಮ್ಮ ಜಮೀನಿಗೆ ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಮೇಲೆ ಕಂಡವರ ಪೈಕಿ ಕೆಂಪೇಗೌಡ ಉಳ್ಳೇಗೌಡ ನಾನು ಹಿಡಿದಿದ್ದ ಮುದ್ದಲಿಯ ಅಂಡು ಮುಗಚಿಕೊಂಡು ನನ್ನ ಗಂಡನ ಎಡಗಡೆ ಕಾಲಿನ ಮಂಡಿಗೆ ಹೊಡೆದು ಆಗ ನನ್ನ ಗಂಡ ಗಿರೀಶ ಆಯ ತಪ್ಪಿ ಕೆಳಗಡೆ ಕುಳಿತುಕೊಂಡ. ಅದೇ ವೇಳೆಯಲ್ಲಿ ಜಯರಾಮನವರು ನಾನು ಹಿಡಿದಿದ್ದ ಒಂದು ಕಬ್ಬಿಣದ ಬಾವಿನಿಂದ ನನ್ನ ಗಂಡನನ್ನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನನ್ನ ಗಂಡನ ತಲೆಯ ಮೇಲೆ ಹೊಡೆದರು. ನನ್ನ ಗಂಡ ತಲೆ ಕತ್ತಿಸಿ ಕೊಂದಾಗ ಆ ವೇಳೆ ನನ್ನ ಗಂಡನ ಎಡಭುಜದ ಮೇಲೆ ಬಿತ್ತು. ಎಡಭುಜ ಕತ್ತರಿಸಿ ರಕ್ತಗಾಯಗಳು. ಸದರಿ ಜಯರಾಮ ಮತ್ತೊಂದು ಸಾರಿ ರಾಮನನ್ನು ಬೀಸಿ ಮತ್ತೆ ತಲೆ ಮೇಲೆ ಹೊಡೆದಾಗ ನನ್ನ ಗಂಡ ಎಡಗೈಯನ್ನು ಅಡ್ಡವಾಗಿ ಹಿಡಿದಿದ್ದರಿಂದ ಸದರಿಗೂ ನನ್ನ ಗಂಡನ ಎಡಗೈಗೆ ಬಿದ್ದು ಕತ್ತರಿಸಿದ ರಕ್ತಗಾಯವಾಯಿತು. ದೇವಮ್ಮ ಮತ್ತು ಲಕ್ಷ್ಮಮ್ಮ ಮತ್ತು ಕೆಂಪೇಗೌಡ ಮತ್ತು ಜಯರಾಮರವರಿಗೆ ಮಗನನ್ನು ಬಿಡಬೇಕು, ಇವನನ್ನು ಕತ್ತರಿಸಲಾಗುತ್ತಿದ್ದು ಅವರಿಗೆ ತುಂಬಾ ಕೊಡುತ್ತಿದ್ದರು. ಲಕ್ಷ್ಮಮ್ಮ ಮಕ್ಕಳಾದ ಆಶಾ ಮತ್ತು ಉಷಾ ನನ್ನ ಗಂಡನಿಗೆ ನಮ್ಮ ತಾತನ ಜಮೀನಿಗೆ ಏಕೆ ಬಂದಿದೆ ಎಂದು ಬರೆಯುತ್ತಾ ಶ್ರೀ ಜಯರಾಮನವರಿಗೆ ತುಂಬಾ ಕೊಡುತ್ತಿದ್ದರು. ಲಕ್ಷ್ಮಮ್ಮನ ಗಂಡನಾದ ನಿಂಗೇಗೌಡ ಜಯರಾಮ ಅಂಡ್ ಕೆಂಪೇಗೌಡರಿಗೆ ಈ ನನ್ನ ಮಗನನ್ನು ಬಿಡಬೇಡಿ, ಇಷ್ಟೇ ಕತ್ತರಿಸಲಿಕ್ಕೆ ಎಷ್ಟು ಖರ್ಚು ಆದರೂ ನಾವು ನೋಡಿಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಕುಮ್ಮಕ್ಕು ಕೊಡುತ್ತಿದ್ದರು. ಗಲಾಟೆ ಜಾಸ್ತಿ ಆಗಿದ್ದರಿಂದ ನಾನು ನನ್ನ ಮಗ ಸಂಜಯಗೌಡ ಬಾಯಿಗಳಿದ್ದರು. ಪಕ್ಕದ ಜಮೀನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಕಡಗವಾಡಿ ಗ್ರಾಮದ ಆಳೆಗೌಡರ ಮಗ ಸತೀಶ ಮತ್ತು ಚಿಕ್ಕಮಾರಹಳ್ಳಿ ಗ್ರಾಮದ ನಿಂಗೇಗೌಡರ ಮಗ ಅನಿಲ್ ಕುಮಾರ್ ಮತ್ತು ಗೋರೇಗೌಡರ ಮಗ ಪ್ರಕಾಶ ಹಾಗೂ ಮಾಯಿಗೌಡರ ಮಗ ಓಡಿ ಗಲಾಟೆ ನಡೆಸಿ ಸಮಾಧಾನ ಮಾಡಿದರು. ಆಗ ಮೇಲೆ ಕಂಡವರೆಲ್ಲ ಈ ದಿವಸ ನೀವು ಬದುಕೊಂಡಿವಿ, ಇನ್ನೊಂದು ದಿವಸ ನಿಮ್ಮನ್ನು ಮುಗಿಸದೇ ಇರುವುದಿಲ್ಲ ಎಂದು ಬರೆಯಬೇಕಾಗಿ ಅವರು ತಂದಿದ್ದ ಸುತ್ತಲಿ ಮತ್ತು ಕಬ್ಬಿಣದ ಸಾಮಗ್ರಿಗಳನ್ನು ನನ್ನ ಗಂಡ ಅವರನ್ನು ತುಂಬಾ ಸೋಮವಾರ ಪ್ರಶ್ನೆ ಪತ್ರಿಕೆ ಹೋದರು. ನಂತರ ಚಿಕಿತ್ಸಾದಲ್ಲಿ 102 ದೂರವಾಣಿ ಕರೆ ಮಾಡಿ ಅದನ್ನು ತಿಳಿಸಿ ನನ್ನ ಗಂಡನನ್ನು ಮಂಡ್ಯ ಜಿಲ್ಲಾ ದವಾಖಾನೆಗೆ ಕಳಿಸಿದ್ದಾರೆ. ನನ್ನ ಗಂಡನನ್ನು ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಬೇಕೆಂದು ಹಾಗೂ the complaint has been made before the police. As per after the receipt of the complaint, the police initially the PW 12 who is the ASI received the complaint. As per the complaint, the FIR has been registered. It is marked as Exhibit P13. Page number 140. This is the FIR is police.
Yes, sir. Then who are the witnesses have been supported on the parts of the prosecution to prove the guilt of the case? Who are the witnesses have not been supported to the case of the prosecution? What is their evidence?
PW2 is not injured witness, and also he is the husband of the PW1 complaint. PW3 the eyewitness of the incident he has not supported the case of the prosecution. PW4 also not the eyewitness of the incident, but he has not supported the case of the prosecution. PW5 also not the eyewitness to the incident, he has not supported the case of the prosecution. And PW6 issue who certificate as per the exhibit B, page number 113.
Yes.
What
about PW7, sir?
PW7 the signature of the signature exhibit P1. He has witnessed the complaint.
What about P8, sir?
P8 he has witnessed the exhibit P11 Caesar Panchana. He has hardly supported the case of the prosecution. Exhibit P9 the PW9 Commission, who is the witness to the exhibit P10. Photos of the incident.
Yes, sir. PW10?
Hardly supported the case of the prosecution.
Yes, sir. What about PW10, sir?
PW10 he is a witness to PW10 he is a medical record officer. Who is issued MLC register as per exhibit P7.
What about PD11?
PD11 FSR officer who has issued P12 as per FSR report.
What about P12?
PW12 initially ASI.
ASI.
Yes, he has received the complaint. He has signed the signature as per P1P.
Then IO in part.
IO in part.
Then what about 13, sir?
PW13 he has conducted the investigation. Finally, he has filed the charge sheet.
Yes, IO.
He is IO.
Then what about 14, sir?
PW14 who is the surgeon was issued case sheet as per exhibit P23. Plastic surgeon.
P23.
P23.
Case it.
Yes.
Yes.
As per the wound certificate, as per the statement given by the doctor, the injuries are serious in nature.
Exhibits P6.
P6.
That is PW6 Pushparani.
Yes, sir. PW6.
We issued one certificate as per exhibit P6.
P.
But PW14 Ramesh KT, who is also doctor,
Yes.
who issued the case sheet at exhibit P23.
Please. P23.
Yes, sir. FSL report, it is at exhibit P12 issued by S. Radha.
Yes.
There's IO, that is PW12.
12.
Is an IO in part.
Yes.
NM Punacha, who is an IO and who led the charge sheet against it.
Please.
This is the
This is
Sir, what do you about the findings that is rendering an acquittal judgment by the trial court? Any infirmities are found?
There is some discrepancy in the statement. The others were instigated. Accused number one.
The direct attack attributed against accused number one, Kempe Gowda alias Plegowda, Jayaramu alias Busu. But rest of the accused number 3 to 7, they are only the instigators, assist to the accused number 1 and 2. That is only the nutshell of the entire prosecution came. If your argument is over, sir?
Eyewitnesses, they have supported the case of the court. Meaning, moreover, they are included witnesses. Their evidence cannot be brushed aside. Since because other witnesses are included, they are not supported. Because merely they are not supported because the case of the prosecution, the main some evidence of the legal one and legal. Who are the eyewitnesses are also the witness. And moreover, the as of the doctors who said the case will not corroborated by the evidence will not be other witnesses also. Therefore, will not be whatever the trial court will not error will not be putting in your respondent accused. Therefore, my submission will not the accused will not.
Then what do you say about the nature of injuries indicates in own certificate at exhibit space 6?
Exhibit is page number 130.
That is one certificate at exhibit space 6 issued by that Dr. P.W. Toll. One certificate at exhibit space 6. According to opinion expressed by the doctor, nature of injuries.
All the injuries are
Previous in nature. Then any differences between 324 of IPC and 326 of IPC except the word use fracture? If there is a grievous injury, it is correct. Even it is hit under section 324 of Indian Penal Code 1860. But what do you say about the grievous ingredients relating to section 307 of IPC?
attempt to commit murder.
Attempt to commit, but not completion.
Not completion. There must be some attempt to take away the life of the
Injured.
injured.
That is PW1.
As per the complaint, there is very much clear, they specifically stated that, or
Yes. In 307 of IPC, it is definite about in respect of elements of intention or knowledge. If there is an intention, but there is no knowledge, what shall we do? If there is a knowledge, but there is no intention. If there is an attempt, but no knowledge, no intention, no attempt. Normally, mens rea, it consists in 4 elements. One is intention, knowledge, attempt, and completion. Intention is there, but there is no knowledge. If there is an intention, and also if there is a knowledge, but there is no attempt. If there is an attempt, but it has not been succeeded, then what shall we do with the ingredients of 307? 307, it is as good as very closely to 300 or 302 of Indian Penal Code. It is alive, 307, sustained with some grievous injuries. It is sit under section 320 of Indian Penal Code 1860, designated injuries 1 to 8. But 319 of Indian Penal Code 1860, that hurt in the sense whether injuries is also hurt, Then verbally abusing, it is also amount to hurting to the human body. Yes, sir.
Charges there for 324 and also 307.
307.
Even your witnesses, you know, they don't know most of them. They have clearly supported the case of prosecution. Because one is because of two,
Some civil in nature, it will be turned into criminal in nature.
as per the complaint about there was a
Civil in nature, it will be turned into criminal nature. In criminal nature, turned into 324 and 307 of Indian Penal Code, but 143, 147. Unlawful assembly. 447. Even whether 324, that is 140, or end with 149. The metal objects, MO1 shirt, MO2 banian. How do you deepen section 149 of the Indian Penal Code 1860? Because metal objects, it is only shirt. Shirt is not a dangerous weapons or dangerous objects. The banian is also not a dangerous object or dangerous weapons. How do you deepen section 149 of the Indian Penal Code 1860? Sir, it is your case, sir.
Land application, 447, there is some document about the land. RTC ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಲ್ಯಾಂಡ್ಸ್ ಬಗ್ಗೆ ಎಕ್ಸಿಬಿಟ್ಸ್ ಏನು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. To trespass ಅಂದ್ರೆ there must be some, but on the other hand they have produced defense suit, decree, judgment, array, copy. But you are not produced to show 447 land belongs to whom ಅಂತ. No documents are produced, Allah. Exhibits P1 to P23, there is no document.
Yes.
Yes. There was another criminal case, right? D6, CC 728 of 2002. Girish PW2. 341, 354, 506. The Twitter.
Section 147. Punishment for rioting. 148. Rioting armed with deadly weapons. But 147, it is a punishment clause relating to the preceding section of 146. What is rioting? In a rioting, whoever is guilty of rioting shall be punished with imprisonment of either description, so and so, so and so. But 148, rioting armed with deadly weapons. Then section 146, it is a definition section. Definition sections relating to 147 and 148. In 146, whoever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly, every member of such assembly is guilty of the offenses of rioting. Rioting, it is a punishment of section 147. Then rioting in a greater extent of 148, it is indicates as armed and deadly weapons. Here is where is deadly weapons? Because 147 and 148 of Indian Penal Code, closely to read the ingredients. Then 146 preceding section. Then section 141, unlawful assembly. It is a definition section. An assembly of 5 or more persons is designated an unlawful assembly if the common object with the person composing that assembly is so and so, firstly, secondly, thirdly, fourthly, and fifthly. (143) it is a punishment clause. 143 it is a punishment clause relating to the preceding section of 141 and 142. Sections 141 to 148 inclusive of 149 of Indian Penal Code there are in all 9 sections in this relating to unlawful assembly. Every section having its own importance and also having its own meaning. Unless 141, there is no 142. 141 and 142 must be read together. Then that 141, 142 must be read together with 143. 143 is a punishment clause in between 141, 142, and 143. But 144, 145, it must be read together. Then 146, 147, 148, it must be read together. Then only we should have able to understand what is unlawful assembly. Otherwise, it is not so easy. Simply because we are saying that and also stated that 149 of the Indian Evidence Act, 149 of the IPC, it is with other offences. But section 34, it is a common intention. There is an intention, but here is an object. Object to a specific object. Unless the ingredients of each one of the offences, 143, it is a punishment clause. The ingredients of 141 and 142, it should be established. It should be facilitated by the prosecution. Even 147, punishment for writing, should be established the ingredients relating to what is writing under section 146. Unless the ingredients of the aforesaid provision of Indian Penal Code 1860, it is not so easy for arrival of a proper conclusion with appreciation as under section 3 of the Indian Evidence Act 1872. All right, sir. Your argument has to be taken on paper. Yes, Mr. Saras Chandra. Yes, address your argument. Tomorrow. All right. Your argument is also on tomorrow. Learned SAGP for state. So cry K. It's also the Learned Counsel M. Saras Chandra for R1 to R7 being arranged as accused or present before court physically. However, in this appeal, heard argument of the Learned SAGP for state. And so also the counter argument advanced by the Learned Counsel for R1 to R7 is on record. And also be present before the court physically. Therefore, it is said that heard arguments in toto. Hence, the matter be listed on 9th of February 2022 for dictating judgment. Madam.